Can you hear me now? I don't know what's the wrong. No. Just give me a second then, guys. Let me check what's the issue with the. But it's working. Yes, yes. Okay, fine. Thank you. Okay, so we'll have to go back from the beginning. Okay. So basically, from last class, we have started ahead with Contract Act. Contract forms one of the basic aspect of your CLAT preparation. So in last class, we discussed some of the basic from the contract perspective, as like what is offer, what is acceptance, how an agreement is being formed. So agreement is where there's an offer plus acceptance, it results into an agreement. Then when we talk about agreement which is enforceable by law becomes a contract. So agreement can be for illegal things also, but for that you can't go to the court, you can't tell the court that there was an agreement between A and B to kill someone. Now the person has killed, the other person is not paying the money. The court will not be entertaining your petition. Court expect from you that once you are coming before the court for certain remedies, you should come clean hand. That is one of the basic thing you can expect. I mean, you have to follow if you want some remedy from the court. Now keeping that in mind, agreement can be for illegal things, agreement can be for legal things. Contract is only those agreement which is for legal thing, that means for which you can go to the court, you can claim your rights. For example, if there was a contract between A and B for painting of the house, A painted the house, now B if is not paying the money, then A has an option of going and filing a suit against B. Here when we talk about agreement is a bigger, you can say, agreement is having a bigger concept. Agreement is a kind of bigger thing. Contract is a subset of agreement. This is what we discussed in the last class. Then we also discussed that there must be some legal relationship, or there must be an intention to enter into a legal relationship. Unless and until you have an intention to get into a legal relationship, legally binding relationship, it cannot be called as a contract. For example, if there is a, you invite your friend for your birthday party and they didn't turn up, so you will not be filing a suit against them saying that you didn't turn up, mera sara khana waste ho gaya, now I'm going to file a suit against you. Because here it is out of friendship you have called them, there was no intention to enter into a legally binding relationship. Similarly, if your father promises you that you will get into NLS Bangalore, I'll give you the latest model of iPhone, so there also it is out of love and affection, because he wants you to get into NLS Bangalore, and that is why he's motivating you to study by offering or saying that I'll be giving you the latest iPhone. So in that case also, there's no intention between you and your father to get into a legally binding relationship. So in that case, it cannot be called as a contract. For contract, the intention must be to enter into a legal binding relationship. For that, the intention is basically that in case there is a breach, you would be going before the court of law. You would be asking the law to enforce the same. Then we discussed about what is offer, what is acceptance. We also discussed about type of offer, specific offer, and general offer. General offer is for public at large, specific offer is for one individual. Then we also discussed about the other idea as to, I mean, cross offer, counter offer. Cross offer is you making the same offer, me making the same offer, both of them are crossing in the transaction. So it's a cross offer. Counter offer is where I said that I want to sell my, car for 1 lakh. You made an offer saying that no, you want to purchase my car only for 50,000. So there is no acceptance on your part. You have made a counter offer. You want me to sell my car at 50,000. So again, there cannot be a contract. Then we also discussed about why communication is very important. Unless and until you communicate to the other party that yes, you have accepted the offer, then in that case, there cannot be a contract. For example, again, the same example that I want to sell my car. I made an offer to you all that I want to sell my car for 1 lakh. Now you thought that you will be purchasing my car, but you did not ever convey this to me. You just thought that I'll purchase a car for 1 lakh, but you did not inform me about the same. Later on, when I sold this car to somebody else, you filed a suit against me saying कि मैंने तो सोचा था कि आप मैं कार खरीदूंगा या खरीदूंगी. It cannot be called as a contract because you have to communicate your interest. Unless and until you communicate your interest, how the other party will get to know that there is a contract? So, communication of offer, sorry, there's an acceptance. Communication of offer, communication of acceptance is very much essential. Here, the example is also saying A own 3 flat XYZ. B calls him and says he is willing to pay rupees 1 crore for his flat. Which flat? Again, it is not clear. When you are communicating something, again, it has to be clear communication. There cannot be any vagueness in it. There cannot be any ambiguity in it. It has to be very clear that yes, if I want to purchase your flat, I want to purchase your X flat for 1 crore, or I want to purchase your Y flat for 1 crore. You cannot just say I want to purchase. Which flat? There is no clearance there is no clear communication about the same. Similarly, the other example says B calls A and says he's willing to pay 1 crore for his flat X. A says, well, let's meet up and let's talk about the detail. Again, there is no acceptance. He did not say that I want to purchase your flat for 1 crore. He said, बैठ के देखते हैं, decide करते हैं, कुछ negotiate करते हैं. So it can be again called as a counter offer sort of thing. It cannot be called as a communication. Then this is something which I had left that I'll be taking this into next class. But before that, I had also asked you guys to solve CLAT 2021 ka passage. So the first thing is invitation to offer. How does it play? So invitation to offer is not a offer. Invitation to offer is basically you making or you inviting people to make an offer to you. For example, let's say when there's a government tender. So government if is coming out with a tender. So government is here not giving you an offer. Government is inviting you to make an offer to them. So let's say if there's a tender for school construction, government school in your city. Now all 10 of us went ahead and filed the tender. Now government has an option of choosing your tender or my tender. So in that particular case, it can be called as a, now I am the one who is making the offer, not the government. Government is just inviting you to make an offer. Similarly, when you go to a shop, you find something on display. So it is not that the shopkeeper is giving you offers. Shopkeeper is inviting you to their shop. Now you go and tell them that, okay, I want this product. Then they have the option of selling it or not selling it. So this is what is invitation to offer. It is different from offer. The next one is concept of postal rule. This is something which CLAT had asked in CLAT 2021 paper. So when we say concept of postal rule or non-instantaneous mode of communication, it actually tells you when the contract gets completed or when the person is bound to perform the contract. We'll understand this through a very simple example. Suppose X posted a letter to Y on 13th of April. This letter reached Y on 14th of April. So the offer is getting completed on 14th of April. Now, Y posted back him a letter saying, I am ready to purchase your car on 14th of April itself. The moment Y posted this letter telling that I want to purchase your car, now X cannot sell this car to somebody else. X is bound to perform the contract. But Y will be bound to perform the contract only when this letter will reach X. So suppose letter reaches X on 15th of April. So now the contract is getting completed on 15th of April. So it is what it is saying. So concept of this works in case of non-instantaneous mode of communication. That is पोस्टल रूल. इन केस ऑफ इंस्टेंटेनियस मोड ऑफ कम्युनिकेशन, लाइक अभी जब हम बात कर रहे हैं यूट्यूब पे बात कर रहे हैं, सो यहाँ पे जैसे ही आई सेड आई वांट टू सेल माय कार, somebody from your side said I want to purchase your car, so it's an instantaneous one. The person is making offer, the other person is hearing the offer, the other person is accepting, I am getting to know about it, so there is no lapse of time. So concept of postal rule is something which is being given under section 4, but in future supreme court while interpreting also stated that section 4 is a kind of, you can say, it's an open ended section, and it does, even though the contract act came in 1872, it does include the non-instantaneous mode of communication as well. So CLAT का वो पैसेज कर ले जो मैंने बोला था करके आने, which is based on concept of postal rule. Shall I share the passage? CLAT is all about practice. Practice तो करना पड़ेगा. करें? Yes, no. इसमें तो करेंगे. So I hope this passage is visible to everyone. Can you see it? You can read it, na? No, sorry, not this passage. Sorry. This one, passage 4. Once you are done reading the passage, let me know. Done, guys? So the passage is basically saying what is communication when it gets complete. The passage is focusing on both the aspect communication through postal rule and communication through non-postal rule also. So considering that if you read the entire passage, the first few lines are focusing on the non-instantaneous mode of communication. The last two, three lines are defining the telephonic mode of communication. Now we'll read the first passage, which is first question. Uh, it is too blue. You can't see it. Okay, so I'll read the passage. Just give me a second to explain it to you. So, the passage says communication is when complete. The communication of proposal is complete when it comes to the knowledge of person to whom it is made. Then the communication of acceptance is complete as against the proposer when it is put in the course of transmission. So basically, just to explain you again, whatever we have stated or we have discussed just now through this particular passage, this is the concept of postal rule. Whatever example I gave, this is the same thing which is mentioned in the passage format. Now, talking about the first question. So let's read the question itself. Hope you can answer it. S wanted to purchase shares of a company, and he communicated his offer to buy the share on March 1st, 2021. A letter of allotment of share addressed to S, which is an acceptance of the offer to purchase share, was posted by the company on March 10, 2022. But the letter never reached S and was lost in transit. So, in the given situation, whether the contract is completed or not, I'm just making it very simpler for you guys. That okay, S wanted to purchase a share. He communicated his interest to the company. Company agreed for it. Company posted an acceptance letter also that yes, we are selling you this share. Now, the letter never reached S. is it got lost in transit. So can we say that the contract is complete against both the person, or the contract is complete against one person? If so, what will be your answer? I hope question is clear. We'll have to figure out something else for next class when I am sharing the actual CLAT paper. A. Communication of acceptance is not complete as against S, which is the wrong choice. Here हमने भी क्या पढ़ा कि जैसे ही एक्सेप्टर लेटर पोस्ट करेगा ऑफरर बाउंड हो जाएगा. हियर ऑफरर इज एस. सो द मोमेंट कंपनी पोस्टेड द लेटर, even though the letter never reached S is bound to perform the contract. Na? Company will be bound to perform the contract only when the S will read the letter. In this case, S couldn't read the letter because it got lost in the transit. So considering that, contract is complete against S and not against the company. So keeping that in mind, C is also not the right choice. Here, the right choice is option B. Communication of acceptance is complete as against S, however, not complete against the company. I hope it's clear now. ऑफरर तब बाउंड हो जाता है जब एक्सेप्टर लेटर पोस्ट कर देता है, और एक्सेप्टर तब बाउंड होता है जब ऑफरर वो लेटर पढ़ता है. यहाँ पे ऑफरर एस है, एक्सेप्टर कंपनी है. कंपनी ने जैसे ही लेटर पोस्ट किया, एस बाउंड हो गया. बट कंपनी वॉज नेवर मेड बाउंड टू परफॉर्म द कॉन्ट्रैक्ट. वाई? बिकॉज वो लेटर कभी एस के पास पहुंचा ही नहीं. एस कुडंट रीड द लेटर, सो द कॉन्ट्रैक्ट डिड नॉट गेट completed and company is not bound. I hope it's clear now. Going to the second question. The second question says A, who is in Mumbai, makes an offer to offer for supply of goods to B, who is in Delhi, via a mobile phone call. During the same call, A's offer is absolutely and unconditionally accepted by B. According to the terms agreed between A and B, goods are to be supplied at Pune and payment is to be made electronically. In the given situation, where is the contract concluded? Mumbai, Pune, Delhi, कहाँ पे होगा या कहीं पे नहीं होगा? Because it's a telephonic communication. Anyone? चलो इसको थोड़ा और सिंपल करते हैं. Let's understand me making an offer to you that I want to sell my car. I am making this offer from Delhi. You are hearing this offer from Chennai. Now you posted an accept. I mean, you said on this video call only. Let's say there's a video call between me and you. You said yes, you want to purchase my car. Now that yes is being heard in Delhi, if the question and the contract is about supply of goods and services in Hyderabad, everything is supposed to be done in Hyderabad. So the question is where the contract gets completed, in Delhi, in Chennai, or in Hyderabad. If you answer this, you can easily answer question 82. कहाँ पे होगा? Mumbai. Yes. Because yes is being heard in Mumbai. In my case, yes is being heard at Delhi. So the contract will get completed at Delhi. In my mera example, in the question which is given, I mean question number 82, the right choice will be Mumbai because X is making the offer from Mumbai. And when the other person from Delhi is saying yes, that is being heard at Mumbai. So considering that, Mumbai is the right choice. The next one, 83. Reading the question for you guys. X, who is in Gandhinagar, makes an offer for sale of second-hand luxury car to Y, who is in Jammu, via an email sent on January 15, 2021 at 2:03 p.m. X offer is absolutely and unconditionally accepted by Y via an email sent on January 15, 2021 at 4:04 p.m. The email communicating acceptance is read by X on January 15, 2021 at 7:05 p.m. In the given situation, when is the contract concluded? क्या होगा इसमें आंसर? As against X on January 15, 2021 at 4:04 p.m. and against Y on January 15, 2021 at 7:05 p.m. B as against Y. B is obviously not the correct choice. C is also not the correct choice because final thing is happening at 7:05 p.m. So you have to choose between A and D. क्या होगा आंसर इसका? Here, as per the CLAT official key, the answer is option A, as against X on 15 January 2021 at 4:04 p.m. because Y posted the letter at 4:04 p.m. and as against the Y on January 15 at 7:05 p.m. because X read the letter at 7:05 p.m. So, as per the CLAT answer, the right choice is A. But if you ask me, for me, the right choice is option D because question is asking contract कब complete हुआ. So contract got completed at 7:05 p.m. Contract question is not asking when the contract got completed against X or Y. So considering that, according to me, the answer shall be D because what the question is asking, D is more suitable one. But as per the official key, they went ahead with choice A. Next one. X, who is in Agra, makes an offer for sale of second-hand luxury car to Y, who is in Jammu via an email sent on January 15, 2021 at 2:03 p.m. However, the email did not reach Y due to some technical error at the server, which is located in Delhi. Thereafter, X makes a mobile phone call to Y on January 15, 2021 at 4:04 p.m. and makes him the same offer as what made in the email. In the same mobile phone call, the offer is absolutely and unconditionally accepted by Y at 4:10 p.m. In the given situation, where is the contract concluded? This question is focusing on instantaneous mode of communication. बट टू कंफ्यूज द स्टूडेंट उन्होंने ईमेल वाला एस्पेक्ट ऐड कर दिया था. ईमेल तो कभी पहुंचा ही नहीं, तो ईमेल वाले पार्ट पे हमें फोकस ही नहीं करना है. हमें फोकस करना है थर्ड लाइन से, where it is being made through telephonic communication. And as per the telephonic communication, the offerer is in Agra, so the contract will get completed in Agra. The last one is saying when the words of acceptors are spoken into the telephone, they are put into the course of transmission to the offerer so as to be beyond the power of acceptor. The acceptor cannot recall them. In the light of given situation, which are the following statement is true? This is one interesting question. यहाँ पे you can apply the elimination rule. The elimination rule, if you'll apply, question is focusing on telephonic communication. Telephonic communication is an instantaneous mode of communication. So, keeping that in mind, if you look at option 3 and if you look at option 4, both the option is saying the communication being non instantaneous. So keeping that in mind, 3 and 4 rule out हो गया. अब हमें 1 और 2 में decide करना है. One is saying the communication being instantaneous, the contract immediately arise. True, because we just read that. Second is saying the communication being instantaneous, the communication of acceptance is immediately complete as against the proposer as well as acceptor. This is also we discussed. The moment one says yes, both the parties are bound to perform the contract. So considering that, here the right choice would be option B, which is 1 and 2. This is one passage in CLAT 2021, which is from contract. There's another passage also which is on contract. Contract exclude the jurisdiction of court. Passage number 3. So I am hoping that you guys will go back, check, take out CLAT 2021 ka paper and solve this passage. We'll continue with contract in the next class also. Similarly, if you look at CLAT 2022, 3, 4, you'll, or for that matter 5, everywhere they have asked questions from contract. Keeping that in mind, unless and until you solve the questions from actual CLAT paper, you will not understand the type of question they are asking. You will not understand ki if we are reading the static portion, like if we are reading these things, whether it is relevant or not. It is relevant because CLAT has asked questions from these topics. So you have to keep these things in mind while preparing. And CLAT is all about practice. And in the last class only, I'd asked you guys to come prepared solving this message. So I'm hoping in next class you'll come prepared, solving all 5 years ka paper. You'll check wherever they have asked CLAT ka contract based question so that we can discuss in the class. So this is all about today's session, guys. If you have any question, you may ask. If not, then we'll see you guys in the next class. Any question? Okay. Thank you, guys. See you in the next class. Thank you.